Services.
Robert Sanderman. I'm also a housing attorney at Queens Legal Services.
And we're doing this training in collaboration with MinKwon Center. So, MinKwon Center, they're a community organization based out of Flushing, and they work with the community on a variety of matters, but one of them is housing. They work with tenants to assert their rights, to learn about their rights, and to push back against, harassment or gentrification, things like that. So we are doing this workshop on a variety of topics. We have a slideshow prepared. I know not everyone is on through the Zoom or with their videos, so they might not see the slideshow, but we'll email it out later as well if you want to refer to it. And yeah, at the end, we'll have a Q&A session and some next steps, numbers you can contact if you want to talk further to MinKwon or Queens Legal Services. So great. I'm going to now share my screen. And let's do that. Okay. I think everyone sees it, right? I'm just going to leave it like this. So it's kind of like the whole thing is not exactly the presentation, but you can see the text. Let me know if you can't see it, if anyone's having issues. Okay, so I'll get started. Our first topic is harassment. And, especially during this period, but before even, a lot of tenants face harassment from their landlords. And it's defined under the Housing Maintenance Code. There's a catch-all category for it. So it is defined as repeated acts or omissions of such significance as to substantially interfere with or disturb the repose, peace, or quiet of any person lawfully entitled to occupancy of such dwelling unit. So that's kind of a catch-all category, right? Like there are also 20 other specific categories outlined, which we'll go into later. But basically, when your landlord is behaving in such a way to make you vacate your apartment, they're harassing you, right? And some specific examples. So if they use or threaten to use physical force against you, or if they make repeated interruptions in essential services, like your gas, your heat, hot water, or if they make buyout offers without mandatory written disclosure. So sometimes the landlord will say, if I give you $10,000, will you leave by the end of this month or by, a week from now? Things like that, right? Or if your landlord repeatedly visits you outside normal business hours, which is like 9 to 5, or in an abusive way, like if they just, without giving you notice or without knocking, the typical formality, just kind of barge in. Or if they request documentation of your citizenship status, which falls under kind of this larger area of harassment, which is under I'm just going to mute everyone. Okay, there you go. Which falls under the Human Rights Commission and the New York City Human Rights Code, which is if your landlord discriminates against you based on a protected class. So one of them is, national origin. So if they repeatedly ask you for documentation of your status, that also is considered harassment. And now, during this period, there's been a new provision added to the harassment code, which prohibits threats based on COVID-19 employment loss, essential employee status, or infection. So if your landlord repeatedly asks you for the rent, despite you telling them that, you can't pay it because you've lost your job, or if they say you can't have visitors, or if they say, I'm just trying to think of things that we've heard through our hotline, or if they say if they like unreasonably limit, your ability to even like leave the apartment, things like that related to COVID-19. So basically the takeaway is harassment is pretty broad, and the idea is your landlord can't do abusive or, can't behave in an abusive way to try to make you vacate your apartment. So another example of harassment is the failure to make repairs. So, if you let your landlord know that you have conditions in your apartment and they continuously, refuse to make those conditions, do nothing about them, that's also a form of harassment. And so repairs or conditions in your apartment can be classified into three separate types. And this is done by HPD, or Housing Preservation and Development, which is a city agency. So there are those that are called C violations that are immediately hazardous. So this is when you don't have like essential services like heat, hot water, or gas. Heat during the heat season, which is, I think, starting now, October or mid-October to, I think, like the end of March. But it also includes if you have broken or defective appliances in your kitchen, bathroom, if you have holes in the wall or floor that, allow like pests and rodents to get in, if there are kids under 7 in your home and there's lead-based paint, and if there are minors present in your home and there are no window guards. Then you have Class B violations, which are considered hazardous. So these are like water leaks from your ceiling, mold in the bathroom or kitchen, broken cabinets, cracks, broken door handles, roaches or mice, bed bugs, and no smoke or carbon monoxide detectors. And lastly, there are A violations. Did I go here? Yeah, which are considered not hazardous, but still these repairs should be made by the landlord. And they include peeling paint or plaster, non-uniform paint, or like leaking refrigerators. So of course, this isn't an exhaustive list. Like there are far more conditions that could fall under these three. The important thing to know is the only ones that aren't necessarily considered repairs are things that are maybe like aesthetically wrong, like if you have mismatched tiles or non-uniform paint, or if maybe some condition is caused like not as a result of like time or wear and tear, but like suppose a lot of like if you have children and like their toys get clogged in the toilet, something like that. But otherwise, it's a condition that that the landlord is responsible for repairing. So all of that to say, you have harassment, repairs. What can you do, right? What actions can you take if this is something that you're dealing with? Well, one, you can write a letter to your landlord, because notice is really important, that you've let your landlord know that in terms of repairs, that you have conditions in your apartment that need fixing. So there's actually this website called Just Fix, and we'll send out the links in the chat, but also when we send out this PowerPoint, we can also send the links. Just Fix is a website that lets you start a letter to send to your landlord. So I think there's kind of a template already, and you kind of fill in the fields, like what exactly are the conditions in your apartment, and then you just fill in your landlord's address, and they'll mail it to them by certified mail, which is wonderful. So yeah, letting your landlord know, giving them notice is an important first step. You can also, if after you send that letter and you hear nothing back, or nothing happens in your apartment, you can call 311. So 311 is the city hotline for quite a few things, but one of them is repairs that you need done in your apartment. And what this does is it kind of triggers a process. So you'll have a complaint, right? That you can do it. You can either call or actually do it online. I didn't write that down. So then the complaint will actually be online on the HPD website for your specific apartment building. And then an inspector from HPD will come and visit your apartment to look for those conditions to see if indeed they exist and there's a violation, right? One of the violations that I listed before, either A, B, or C. And then if there are violations, then the HPD inspector will note them and HPD will send a notice to the landlord saying, here's a violation, you have this much time to correct it. And if they don't correct it, they can be subject to civil penalties and things like that, which if they don't pay can prevent them from getting like permits or being able to do certain things with their buildings. So sometimes it is an incentive for them to actually get the repairs done. Another thing you can do, I think we'll go into this more later as well, but if you happen to live in like an attic or basement apartment, we're going to go into which types of those are legal versus illegal, but sometimes calling 311 isn't the best if you're in an illegal apartment, because it can trigger a whole nother process. which leads to a vacate order in your apartment. So we'll go over that in a bit more detail later, but I do want to point that out because sometimes that does happen. But yeah, another thing you can do is start a tenants association. So what that is when you band together with other tenants in your apartment, because most likely, if your repairs are being neglected, your other neighbors' repairs are also being neglected. So you can, band together to let your landlord know this is a common problem throughout, that you won't stand for, that you demand repairs. And the reason an association is powerful is because we know there's strength in numbers, right? When people get together, when they either write a letter or take actions against their landlord, that can actually really compel the landlord to do what they're supposed to do. And if you're interested in forming a TA, MinKwon, they work with a lot of TAs throughout Flushing and around that area. So they can give you some more advice and like kind of best practices for forming one. And like I said, at the end, we'll have more like contact information and stuff, so you can reach out to MinKwon. Another thing you can do, and this is kind of, when talking to your landlord just isn't working, you can start an HP action. So HP stands for housing part, and this is basically a lawsuit against your landlord in housing court to either make repairs, provide services, or if you're facing harassment, right? And these are the three things you can potentially get out of an HP action. One is an order to correct. So it can either be an agreement that you make. Actually, I'm going to go into that in a second. Let me just go over the things you can get out of an HP action. So one is an order to correct, which requires a landlord to correct the conditions listed within a set period of time, usually like 30 days. But if it's something really serious, it could be like 24 hours, like no gas, something like that. An order from the court preventing future harassment, and you'll have a court record of the landlord's failure to repair. So what's the usual timeline? First, you need to file a petition. You would be considered the petitioner. You can go to court to do this. Even now, court is open for this purpose. But if you would rather not, you can also use the Just Fix website, which is that same website I referred to earlier, and which, we'll send out a link for. Then you have to serve the petition. So service is when you somehow deliver the petition to the opposing party, so the landlord, and therefore they're on notice that there's a housing court case against them. Usually like the method of service is specified on the petition. So, the specifics will be explained to you when you get your petition back. Then there'll be an inspection if necessary. So if there are no 311 violations, if no one's ever visited your home to see these conditions, the court or you can ask for an inspection to confirm that there are these issues and violations. Then you have the court date. So sometimes, as they should, the landlord comes to court. And so the landlord can acknowledge, yes, you have these conditions, and they can agree to fix them. Or they can also agree to stop the harassment, right? So that's you guys kind of entering into an agreement saying, maybe like the landlord won't admit to harassing, but they agree that they won't behave that way anymore. And those agreements, known as stipulations, they're, stamped by the judge, so they're court orders, right? Like you can go back to court if either side or if the landlord is violating that agreement. Or the landlord can refuse to agree, and then you'd have to go to trial or have like a hearing and present evidence of the conditions. So 311 violations can automatically show that those conditions exist, and of the harassment. So some things to show harassment that we through our clients have seen is text messages, pictures, videos, your own testimony counts. Sometimes, unfortunately, like the police are involved, so if you have police reports, things like that. Then there are also occasions when the landlord does not come to court. Right now, because of the pandemic, the courts aren't exactly always taking defaults the way they used to. But even if they don't come to court, you'll have an inquest, which is basically like the hearing, the trial, but there's just no other side. So you're just able to kind of present everything. So ultimately, you get something out of the court date, whether it be an agreement or an order from the judge, and you should keep track of your repairs or of the behavior that, comes after. And you can return to court if necessary, if the landlord hasn't made those repairs or if the harassment continues. And at that point, you can get civil penalties assessed against them. You can get, a filing of or a finding of contempt against them. There's some more remedies at that point. But yeah, that's what an HP action will generally get you. So again, this is that website, Just Fix, and this is what it looks like if you want to start your case. It's really cool because you kind of just fill in the fields, like where you live, if there are minors in the home, what conditions you have per room, kitchen and bathroom, common like areas, and then they'll fill out the petition for you, send it to court, then you'll get the signed copy back, and then that's when it'll specify the kind of service. And then, the court date and all of that. Now, another thing that you can do if you live in a rent-stabilized apartment. So the way to know if you live in a rent-stabilized apartment is generally, you receive lease, like you have a lease, right? And on your lease, it says rent-stabilized. So you can check through that. But sometimes if the landlords are not following the law, apartments that were built before 1974 and that have 6 units or more, so that you can look your building up, in fact, on that website too, Just Fix, or if you just Google your building, there are a lot of resources for those buildings, including like websites that tell you who owns it and when it was built, things like that. So either of those could mean your apartment is rent stabilized. And what rent stabilization means is that you have certain rights as a tenant there. One, that you're entitled to a renewal lease after your lease expires. Two, that your rent can't go up by all that much. There are regulations as to how much it can go up with every lease. And then three, just all these kinds of protections against eviction, the kinds of repairs that need to be made, etc. There are quite a few, right? So in a rent stabilized apartment, one thing that you can apply for is a rent reduction order. So this is an example or just a screenshot of what that application looks like. It's fairly simple to fill out. And if you are experiencing decreased services, right? Like in the winter, a lot of tenants don't have heat, or if suddenly your gas is cut, or if you've had like broken cabinets for a year now, any of those conditions we mentioned before, if you apply, DHCR is the city agency that oversees rent stabilized buildings. So you'll see it, it's on the top of this page. They'll send an inspector, make sure that condition exists, right? And if it does, they can order that the landlord has to reduce your rent to like the previous legal regulated rent. So it goes down a bit, right? Different for everyone what that amount is. And that can compel your landlord to finally make the repairs because they're now losing out on money, right? So that's kind of it on harassment repairs. There are obviously little details here and there everywhere. If you have questions, we're going to have a Q&A session at the end. So now I'll pass it along to Nilu, who will talk about non-payment cases.
All right. Okay. I guess shall I take next slide? Awesome. Okay, so I'm going to talk a little bit about non-payment cases. There are two main types of cases that are common in housing court. There are non-payments and holdovers. Non-payments are at its core cases for non-payment of rent. So it's if you have been unable to pay rent, the landlord can take you to court for a non-payment case. So in order to start a non-payment case, the landlord is first required to send you this before they can take you to court. So what you see here is the first notice, which is the notice of failure to pay rent. So this is if you have not paid rent by the 5th of the month, the landlord can send a notice that basically kind of giving you, letting you know that you owe rent. And this notice, it'll have the months owed, the time or the amount owed for which months, and then after this notice is basically the landlord will send another notice, which is called a rent demand. And so the rent demand, as you can see, is similar. It also has the months for which rent is owed and the amounts owed. It will say that, typically it's a 14-day rent demand, and it'll say you have 14 days from the date of service to pay this amount. If not, if you fail to pay, the landlord will commence summary proceedings against you, which is a fancy way of saying that basically if you don't pay by the time allotted in the 14 days allotted in the rent demand, then the landlord has the ability to start a court proceeding against you. It's really important that in the rent demand that it lays out specifically how much money is owed and for which months. And the next slide, we'll see kind of the typical timeline of non-payment cases. So like I said, first the landlord will give you a notice for failure to pay rent, and they must serve you with a rent demand. And then if what is owed isn't paid at that point, then they can file what's called a notice of petition and a petition. So this is a document that basically starts the non-payment case in court. And so in the notice of petition and petition, it will tell you to go to court and file what's called an answer. An answer is basically a response that you would make in response to what the landlord is saying in the notice of petition. So for example, if the landlord is saying you owe 2 months of rent for $1,000 per month, then in your answer you can put whatever defenses that may apply in that case. For example, if you already paid the amount owed, or if you dispute the amount owed, if the landlord is alleging you owe more money than you actually owe, there's that. You could also, there's also if you're withholding rent because there are repairs that need to be done and landlord has not addressed them, you can also raise that as a defense. That's called the warranty of habitability defense. Basically that you're withholding rent because certain things have not been addressed by the landlord upon notice. There's also other defenses. For example, if you live in a rent stabilized apartment, as Shati mentioned, there's a legal rent. So if your landlord is charging more rent than what is legally allowed, so if they're charging too much rent, or if they're even refusing to take your rent, these are defenses that you can raise in the answer, which typically the clerk of the court will help you with. But now because of COVID, they are allowing phone answers and allowing more time to file an answer. So anyway, that's kind of the first. So the landlord will file the notice of petition and petition, and that paper will tell you to file an answer. And when you file this answer, that gives you the first court date. And at the first court date, you can request an adjournment to seek representation, or at the next court date, you can appear and present. If you're unrepresented, you could come and you can present your defenses. Again, the defenses, like some of the defenses you mentioned in your answer that I mentioned previously, or you can try to negotiate with the landlord for some kind of payment plan or arrangement. And so if you do make some kind of arrangement with the landlord, you would enter into what's called a stipulation of settlement. So a stipulation of settlement is basically a fancy way of saying it's an agreement that you're making with the landlord to typically repay the money, or you're agreeing on how much is owed and what the payment plan will look like. In a lot of times, what you could do is you could figure out how much is owed, make an arrangement with the landlord to pay it by a certain date, and if you are eligible, you can seek financial assistance to help pay for your arrears, such as a one-shot deal with HRA. And HRA administers one-shot deals, which is a type of emergency rental arrears assistance that can basically help to pay the arrears, and as long as you show that you can afford the rent going forward, that's one of the options for rent to arrears assistance that exists. Okay, and the next slide, please. Thank you. So this is this is kind of for anyone who can see the video, this is a picture of a typical notice of petition and petition. Like I mentioned, you can see that it directs you to go to court to file an answer, because that's kind of, it's unlike other cases, it doesn't give you the court date, so it's when you file the answer that you get the court date. So it's really important that if you're served with a notice of petition for a non-payment case, that you follow the instructions and actually file an answer, because or else you could be found to be in default, and the landlord could potentially get a default judgment for the amount owed. And if that's incorrect, or if that's more money than is actually owed, that could potentially be an issue. So it's definitely filing an answer as soon as possible is in your best interest. The next one. Thank you. Okay, so because of COVID, this year there are a lot of I guess executive orders and protections that have come out for tenants, especially in non-payment in proceedings. So the Safe Harbor Act is a statute that came out basically saying that no tenant can be evicted for owing rent in the COVID period. So basically from March until whenever COVID ends, a landlord cannot seek a possessory judgment, which means that they cannot physically evict you and take over possession of your apartment for any rent owed during this period. However, they can still sue you for the amount owed, and they can get a money judgment. So a money judgment is something that it's basically a judgment that stays on your credit saying that you owe a certain amount of money. But again, they're not able to, for the duration of COVID, which has not ended yet, for this period of time, they're not able to seek possessory judgment. So any monies that you owe, they can still try to collect it, but they're not able to evict you and take your apartment. One of the requirements of this is that the housing court will consider your financial hardship caused by COVID. So one of the easiest ways to show this is if you are on unemployment benefits, you can show that that your income has been affected by COVID, such as loss of income, and therefore being on unemployment. That's one way. But yeah, if you can show some financial hardship caused by COVID, a change in income before COVID and after, that would make you eligible for protections under the Safe Harbor Act. Okay. And this is just this last slide is kind of the notice that the court is sending out now, which is that because of COVID, typically there's a short period of time previously that they would give you to file an answer, but now because of COVID, they are being more flexible and providing additional days, also potentially being able to answer via phone. So this is a notice that now should be, if you are served with a notice of petition and petition for a non-payment, should accompany that those documents. And now my colleague Robert Sanderman is going to talk a little bit about holdovers.
Hi everyone, how you doing? Me again. So similar to what Nilu just described, I'm going to talk about holdover proceeding. So she mentioned there's two types of cases. So there's non-payments, and a holdover pretty much just encompasses everything else. So that could be a violation of the lease agreement. That could be you're causing a nuisance, whether you're making too much noise and affecting the health and safety of your neighbors, um, overcrowding, anything. So you would just have to look at your lease. There's going to be a list of things that might be considered a violation, or it could just be other things embedded within New York law that a landlord can commence to try to get rid of you. The other thing is, even if you haven't done anything wrong, if you don't have a lease agreement, the landlord can still terminate you don't have a tenancy technically. But if you're paying rent, that creates a month-to-month tenancy. So that means if you pay rent on the first of every month, even if you don't have a lease, you still have an agreement with the landlord. But the landlord will still have to move to evict you, even if you weren't paying rent, but you were paying rent at a prior time, or if you had a lease at a prior time. There's still that relationship. The landlord has to commence a proceeding against you, whether a non-payment or a holdover, or else that eviction will be illegal. So that's very important to recognize, and it's also going to come up later when we talk about basement apartments. So even if you don't have a lease, you still have to send a notice similar like this. The new laws came out last year, and depending on how long you've been living in that apartment, the landlord might have to give you more notice. So if you've been there for about a year, the landlord has to give you 30-day notice. If you've been there for like 60 days, if you've been there for at least 2 years, the landlord has to give you 60-day notice. And if you've been there for 3 years or more, the landlord has to give you 90-day notice. This is important because we want to, the law wants to make sure that we ensure stable housing and protect long-term tenants. It also gives you more time to prepare a defense or to seek an attorney that will help you later on in court. So this document is not a court document. This is just a letter from the landlord stating, I'm giving you notice that you have to leave on this date. And if you live in a rent stabilized apartment, the letter might have to say a bit more in terms of exactly why the landlord is suing you. Because if you live in a rent stabilized apartment, you're entitled to automatic renewal leases. So 1 to 2 year renewal leases. So unlike this, where it just says like your lease is expiring, that termination letter will have to say a bit more as to like you violated your lease agreement or something like that. And always consult with an attorney. And as it says here, it's not issued by a Marshal. That comes way later in the process. This is just letting you know that your landlord might bring it to court. Next slide, please. So after, let's say you're giving 60 days to move out of your apartment, for whatever reason you don't move out, either because you want to fight it in court or you don't believe that you should move, the landlord is you're supposed to receive a notice of petition, as Nilu mentioned before, but this one is just going to say notice of a holdover petition. Unlike a non-payment petition, you're not required to answer. The court just automatically gives you a date. So it's supposed to tell you if you're in Queens, to go to the Queens Housing Court. It's supposed to list the address, give you a date and time to show up, tell you what room to go to. Especially now during COVID, you probably wouldn't, if you're being sued right now, you probably wouldn't have a case right now. It would probably be next year, early next year, because the court is currently dealing with the backlog of cases pre-COVID-19. So it's going to be before the courts close, like March 7th. So once the courts go through those cases that are already on the docket, then they'll move on to like newer cases. But it's always important to confirm. But again, they'll give you a date. They probably wouldn't give you a date right now because they're not putting things on the calendar yet. But it's important to follow up with the court if you haven't received a notification. The court usually sends a yellow card to your address to tell you that there's a case against you, when it's going to happen, and when to show up. when you actually do get that court date, whether it's more likely would be in January or even later of next year, it's important for you not to miss that court date. Because if you miss that court date, it constitutes a default. So that just means that no one showed up. So they will give the possession of the apartment to the landlord. Things do happen. So if you had an emergency, you just couldn't make it that day, it's important to go to show up to court as soon as possible and file something called an order to show cause. So that's just, you would go to the clerk's room and just state out your reason as to why you missed your court date and why you want to restore the case back to the calendar so you can defend your apartment. Okay. Next slide, please. Okay, Marshal's notice. So I'm just gonna give you the timeline before we reach there. So pretty much you received your notice of termination, and then you received your notice petition. You're in court now. You show up on your first court appearance. You on that first day, it's likely that the first person you're gonna talk to is the landlord's attorney. You don't have to settle a case with the landlord attorney. You can say, hey, I just want more time. I want an adjournment. I want to have an opportunity to speak to a lawyer. Or you can also just say you want to conference the case with the court attorney and just tell the court attorney that you want an adjournment. The court might refer you to a legal service provider like our office or another office and put you in touch with an attorney, or you can also call Housing Court Answers and other resources to see if you can get an attorney to help represent you. With right to counsel, depending on your zip code, you might be entitled to an attorney. And there's also other factors pertaining to your income or other status where you might be entitled to an attorney. The benefit of having an attorney is they can look at particular defenses that you may have. And there's so many possible defenses, but I'm just gonna name a few. One could be retaliation. So Shati spoke earlier about the warranty habitability and getting repairs done. So if you sued your landlord for repairs and you feel like the landlord is suing to evict you to punish you for doing so, that's retaliation. So that's an argument you can bring to the court to say, I shouldn't be evicted because of this. If the landlord is evicting you because you have a pet, but you already put the landlord on notice that you had a pet and the landlord knew about it, you might have a defense to say the landlord already knew about this pet. If the landlord's claiming that you violated something in your lease, but you addressed that and you cured it and you put the landlord on notice, that can also be a defense to say the landlord said I was doing this and I was continuing to do this action, like having loud parties, but that stopped a long time ago. It was well documented. I have witnesses. That can be like another potential defense. But again, the benefit of an attorney is to look at all that. And another important thing that I haven't mentioned is we want to make sure that you were served properly. So when the landlord gives you the 30-day notice, it's important to know that you actually received it, because if you didn't receive it, then it's really not that useful because you didn't get notice that you're going to get sued. Same thing with the notice petition to petition. The landlord is supposed to serve a particular way, whether in person or certified mail. So it's important to bring that up, and especially when it comes to service, maybe also just keep a log to say when and how you received it, because it might not match the way that the landlord might claim that they sent you the court documents. So what happens, let's say you get an attorney, the attorney might file these defenses that can take up time, that can take months, or maybe if you don't have any defenses, you might settle. So a settlement can look like whatever you and your attorney might figure out. So it's very fact specific and case dependent. So if you just want to move out, maybe try to negotiate how much time to move out. So you would talk to your attorney as to, I do want to move out. I don't want to be here. I want to be here for X amount of months. Or if money is important to you, you can try to argue, hey, I incurred all these expenses, or as was mentioned earlier, seek a rent abatement where you haven't had heat or hot water for a while and you feel like you shouldn't have to pay full rent for that month. So either we go to trial or we do a hearing, or maybe the landlord attorney doesn't want to spend time on that, and they might have more of an incentive to avoid going to trial, incurring more fees, and maybe they're willing to settle. So settlement is a huge part of housing court, because there's so many tenants, so you can't just have trial all day. So sometimes that can like clog the court. So pretty much landlord attorneys are trying to settle as many cases as they can, because they're dealing with like high volume cases. So that's something that can work to your benefit. Again, and if you can't settle, you have the right to go to trial. So if you do settle, the important thing is to know that you're waiving your right to go to trial. In those cases, if you don't think you've been served properly, that's something you have to bring up early on. So you can do a hearing, and maybe we can talk to the process server, the person who allegedly served you, to confirm that they did it properly. These are all things that can get rid of the case, which will give you more time to stay in your home, because the landlord will have to bring the case back. If you do decide to go to trial, make sure that you have all your supporting documentation. So again, if the landlord is claiming that you did something, but you know you didn't do it, but you have proof to show that you weren't there, or you're not illegally subletting the apartment to somebody, it's important to have that documentation for the judge. Another thing that comes up a lot is succession cases and rent stabilized apartments. So that's if someone was on the lease and then that person moved out, and you need to prove that you've been living with that person for either a year or two, you have to get all your documentation together to prove it. So that's the important thing about trial, is making sure that you consult with an attorney, because what we're providing right now is not legal advice, it's just legal education. So you have to check with your attorney for those specific things and make sure that you provide the documents to support your case. So let's say you sign this agreement to move out. What you're doing is, again, you're waiving your right to go to trial, but you also might be agreeing to, you would be agreeing to a possessory judgment, which means that if you agree to move out in 6 months, and you fail to do so, the landlord, the marshal can come and remove you from the premises. So you have to go through this whole process to give the marshal the authority to remove you from the premises. Once that's signed, you're pretty much saying that it's okay for them to get a warrant, which can take maybe a month or two after you sign the stipulation. And let's say October 31st comes, you're supposed to move out already. The marshal might send you a notice after that. It could be a couple days, it could be weeks. It just depends on when they get around to sending it to you. And it's going to look like this. It's going to have the caption, the case caption there. It's going to have the name of the marshal and the contact information. And this is telling you have 14 business days to vacate the apartment, or else the landlord is going to physically remove you and your belongings. You don't want to, it's a very traumatizing experience for that to happen. So that's why it's so important to act on this immediately once you receive it. Again, if you have an attorney at that point, talk to your attorney in terms of strategy, what makes sense, if you want to do it right away, if you want to wait a while. But the important thing is to call the marshal, confirm the date. So like the bottom is going to tell you like the earliest eviction date. You don't want to trust that. You want to do it before that date. You want to talk to the marshal to confirm. And if you also might want to verify that this information is correct, because sometimes mistakes happen. So you might want to look online to confirm the actual marshal's phone number. You might have to call several times throughout the day because no one's answering. And when you do receive a marshal's notice, it's not end all be all. You still have a potential opportunity to file something, again, called an order to show cause. So that's what I mentioned earlier. If you missed your date, but you want an opportunity to still tell your story, you file that order to show cause and you say, hey, I've been trying to move out, but I haven't been able to. I just need more time. The law pretty much can provide you with like 6 months to a year of additional time. Is again, that's very specific to your circumstances. And you just have to show good cause. So it's really up to the judge to determine if you've been sick in the hospital for 6 months and you couldn't abide by the agreement, or something major to work that out. But it's super important to file that because that pauses the eviction. And then once you're heard, then either the judge will accept your request or the judge may deny your request. It's not guaranteed, but it's a tool, a very important tool. Next slide, please. So as a result of COVID-19, a lot of the courts in New York City shut down in mid-March, and advocates and tenants have been organizing to close the court. And what came out of it is a moratorium on eviction that was extended throughout the period. So the moratorium just pretty much meant that no one was getting evicted because of the crisis, because it wouldn't make sense to evict people during a global health crisis. It was pushed further and further out. It expires today, October 1st. So what's expired is the eviction moratorium that covers everything: holdovers, non-payments. You don't need a COVID-19 defense. Evictions aren't happening. It expired today, so that means that after today, people can be evicted. Nilu spoke about the Safe Harbor Act earlier, and this is pretty much what this slide is referring to, the extension of the Safe Harbor Act. So the Safe Harbor Act, as Nilu mentioned, is specific to COVID-19 defense. So before there wasn't an end date, well, there was, before it just says when the phases of the shutdown closes. What this new order does is just extends it through January 1st, 2020. It's just extending it, nothing more. It's just saying that, well, just know that at least through January 1st, 2020, you still have this defense. And what it also does is open it up to prior to COVID. So if you had a judgment and warrant before March 7th, then you can still have this offense. So it's not guaranteed that you won't get evicted, but it's a defense to say, hey, I shouldn't be evicted. This should just be a money judgment. Another potential defense to the eviction is the CDC defense. So that's a form that you download online. That CDC defense is the executive order, national executive order signed by the president that stated that you shouldn't be, it does the same thing the Safe Harbor Act does. And that's through, it's supposed to say December 31st, 2020. So that's through the end of the year to say that if you've been financially affected by COVID-19, then you shouldn't be evicted. You have to, that's more proactive though. You'll have to download the form and fill everything out, and I guess put your landlord on notice to say that you have the CDC defense before they sue you. Whereas the Safe Harbor Act, you can bring up that defense while in court. And again, you have to talk to an attorney as to if and how to bring that up related to non-payments and holdovers. Next slide, please. Okay, so basement apartments. And so pretty much we have, in Queens particularly, we have a lot of housing stock where people live in basement or attic apartments. Some of them are legal, some of them are not legal. So there are like various requirements that will make it not legal. So if there's a boiler downstairs, it doesn't make it safe or habitable for you to live there. If the windows are too small, so it will be hard for you to escape if there was an emergency, that will make it not habitable. The fact that there's only one way to get in and out of the apartment will also make it dangerous. So all these things are put into place because of just experiences in New York City where we have tenement houses and people were just like packed into like small spaces, which created like a lot of safety issues and fires where people were their lives were at risk. This kind of reflects that, but the reality is a lot of people, basement and attic apartments might be the most affordable means and their only access to housing. So as Shotzi mentioned earlier, when it comes to harassment, so if you're calling 311 and you're trying to sue your landlord, it's something you should be thoughtful about in terms of if you do that and then HPD comes and inspects your apartment and they deem that it's not habitable, they can put a vacate order. So we had plenty of clients where either the landlord called DOB out of Department of Buildings out of retaliation to do an inspection and to deem that as a vacate order just to skirt the housing process to bring you to court. So like that's the bad thing about it is more immediate. So if they put a vacate order, it's just saying health and safety issues, you can't be here. I think they set you up with Red Cross where you can like stay somewhere temporarily, and maybe you can file to get your belongings to get access. But it's more like a quicker eviction process, and it's like a different process to challenge. So you would have to challenge the order to say that it is legal or that maybe your landlord should be able to make it legal. So it's not an end all be all. There's ways to get around it by arguing that it could be made legal or your landlord should make it legal or just organizing and figuring something out. But that's just something to be thoughtful about. But if you do live in a basement apartment, you do have rights. You have the same rights as any other New York City resident. Even if you don't have a lease, even if your landlord's telling you to pay in cash and not giving you receipts, it might be important to try to document those things however you can to get like paper receipts to show that you are a tenant, that you've been paying your rent. Particularly during the pandemic, there's been a lot of issues of people being locked out of their apartments illegally, and then it's hard for them to prove that they live there. So if you have smartphones, keep those keep those documents that has your name and address on it to show that you live there, because your landlord should have to go through housing court to properly remove you from the premises and not lock you out. Next slide, please. So this is what a vacate order looks like. Next slide. So new laws last year also stated that it's illegal for the landlord's broker to collect broker's fees. So it's just important to know that there's you can go online for other resources like Department of State to file any issues regarding the broker's license. They're also supposed to not. They also request only 1 month's rent because in the past, particularly with low income tenants, sometimes the landlord is asking for like 3 months rent for security deposit. So that's just not legal as well. So it's something to look out for. Next slide, please. Okay. So suing or being sued in housing court will not affect your immigration status. This is important to know because it's another intimidation tool that landlords use to harass people. A lot of folks who might not have status are afraid to sue their landlord or to be hauled into court. So sometimes landlords take advantage of that. Also, like if you were behind your rent, as was mentioned earlier, and you needed to apply to the city for help or like the subsidy where the city is going to help you pay your rent, it should not affect your status if you're a green card holder, or if someone is petitioning for you. If you're undocumented, you also have a final removal order. The landlord is threatening to call ICE. You don't need to open the door. So there's other safeguards where you can protect yourself against a warrant. You can ask. This is something you should definitely talk to an immigration attorney about, just to make sure when you're in that situation that you're getting the most up-to-date advice because everything's changing really quick. Next slide, please. If you live in a rent-stabilized apartment, like I mentioned earlier, it's an agreement where the landlord has to give you 1 to 2 year renew leases. You're entitled to those. They can't charge you market rate rent. They have to abide by the rent guideline boards. You can request your rent history from DHCR to make sure that you're paying the right amount. You can also sue your landlord for overcharge if you feel like you're not being paid the right amount. You can always Google how much your rent should increase. So this is something that you can do on your own without an attorney to make sure that you're paying the correct rent. A tactic that the landlords would use mostly before the passage of new laws is to do something called major capital improvements, where they can based on alleged repairs increase your rent. So this is supposed to be building-wide repairs, so fixing the roof or the courtyard. You have the power to challenge that. The best thing to do is to form like a tenant association, or just to have like a group of people in your building to challenge it, where you can file through DHCR again to say you want to make sure that maybe they shouldn't have it because there's like the B or C violations that Shotzi mentioned earlier, or it could be that they didn't have a licensed contractor, or that they didn't use a contractor that was unaffiliated with the landlord, or if the improvements weren't necessary. So these are all like important things to bring up. And just lastly, there's something called IA, individual apartment improvements. That's when the landlord's making repairs in your apartment that aren't like normal wear and tear. You can also just safeguard yourself from that by you signing off on it to consent that you agree for this to happen, because what will happen with that is the landlord will also charge you for those things and add it to your rent. And similarly with those, you are entitled to see the canceled checks to make sure that they actually paid what they claim they paid for it, and other things just to keep them accountable to make sure that you're not being overcharged. And I think we're going to jump into the scenarios.
Yeah, so we just have these two scenarios to kind of drive home some of these points, and just see also like how it could be applied in real life, right? Because we talked a lot about just the law. Oh, did I unmute myself? I did? Okay. Okay, cool. Okay, so here's scenario one. I'm gonna move my... Anna lives in a rent-stabilized building. In late March, she was laid off from her job at a restaurant because of the COVID-19 pandemic. She could not pay her rent for April, May, June, and July. For each of these months, although Anna let her landlord know that about her employment and financial situation, he would send her texts and emails saying that if she didn't pay the rent, he would throw away her things and kick her out immediately. She received a rent demand from the landlord in July and just received a notice of petition from the landlord this month. The landlord is trying to collect late fees in addition to the rent. So yeah, I guess the three of us, we could just jump in with anything we kind of see that stands out that's important to know. I can start. One, the landlord sending her texts and emails threatening to kick her out, that's considered harassment, right? And that would actually kind of fall under the new provision of harassment that was added during the COVID-19 period, where it's really like after you've already told the landlord that you're facing a financial hardship, they continue to threaten and intimidate you. So what can she do about that? Well, if there's also, repairs issues she has, or, other forms of harassment she's facing as well, she can start an HP action. And until, for the time being, she can get an order saying landlord cannot act this way, right? And if there are repairs, it's not included in the scenario, but likely maybe there are, she can get an order to correct to have those fixed too. And if you guys want to jump in, I could go into also the rent demand. There was a law passed, it was in one of the executive orders that during this period from March to when COVID ends, landlords can't try to collect late fees. So they can't charge late fees, or legal fees. So, the fact that they're trying to collect late fees, that won't be collectible because it's not allowed. Is there anything else you guys notice?
Well, it seems that she was served with the notice of petition. So I guess like I went over in my section, she should probably she should have received one of the postcards telling her to file an answer. So that's something I don't know. I guess we don't know for sure if whether or not she filed an answer, but that's something. And then also because of COVID, we know that the landlord is not able to obtain a possessory judgment against her, that they're only allowed to pursue a money judgment. So that's something else to keep in mind.
Right. So she can't, for those months, April through July that she couldn't pay, she can't be evicted for that. And, the consequences of a money judgment, yes, it's still like a judgment. It can appear on your credit score, or it can affect your credit score. It can appear in your credit report, but, there's no threat of eviction. So that's kind of, I guess, the goal of the Safe Harbor Act. Yeah, and the only other thing I can think of is, since it's a rent stabilized building, it's important that, she look into whether her rents have been properly increased from renewal lease to renewal lease. If she has repairs, again, to bring those up when she goes to court for the non-payment. Of course, the harassment, you can also list that as a counterclaim to a non-payment action as well. So those are some of the things, in a non-payment scenario to look out for. Okay, and then we can move on to scenario 2, which is holdover situation. So Mark lives on the first floor of a 2-family house. He has been living there for 5 years and never had a lease. In late March, he became unemployed because of the COVID-19 pandemic. He could not pay his rent for April, May, and June. On June 1st, he received a 30-day notice of termination from his landlord, saying he had to vacate the apartment by July 1st. When Mark did not vacate, the landlord threatened to report him to ICE. He just received a notice of petition from the landlord this month. So also here, I guess the key difference is this isn't a rent stabilized apartment. It's an unregulated home. So, because he has and this is unfortunately something we've seen a lot with some of the advice calls we do, that there are tenants in unregulated homes who have been unable to pay rent, and instead of commencing like a non-payment against them, their landlords are commencing a holdover saying, oh, we just want you to leave altogether. So that's something to look out for, because in a rent stabilized apartment, they can't remove you for not paying rent. In this kind of scenario, an unregulated apartment, it's not like they can remove you for not paying rent, but it's more that they have the option to say, oh, I terminate your tenancy now. But here, the landlord did not correctly do it, right? As Rob mentioned earlier, if you have lived somewhere for more than 2 years, your landlord's supposed to give you 90 days notice. And after July 1st, he received a notice of petition. When they go to court, they can present that as a defense and the whole case can be dismissed, buying Mark a lot more time, because then the landlord has to serve a 90-day notice, even though they already went to court and all of that. And clearly, threatening to report someone to ICE is harassment. In addition to an HP action, you can also make a complaint with the New York City Commission of Human Rights, which is something you can Google, and the complaint form is online. I'm not sure if there's anything else you guys want to add.
Similarly, since he was unemployed and couldn't pay for those months that were during COVID, it's important just to collect your documents as well to show that you've been financially affected during that time, and be ready to present that to the judge or your attorney as a defense.
So great, I think we are finally at our Q&A session. So we're opening the floor. If you have a question, oh wait, what's the best? I guess, let me actually stop sharing my screen first. Oh my gosh, let me figure out how to do this. Stop share, perfect. Okay, so let's see.
I think it's still recording, right?
Yeah, and I'll also stop the recording. Yes, thank you.